These parcels of land come with their own characteristics.
Government bills. This council resumes the second reading debate on the protection of the Harbour Amendment Bill 2024. Mr. Tony Che, Chairman of the Bills Committee on the bill, will first address the council on the committee's report. Mr. Tony Che. President, as Chairman of the Bills Committee on Protection of the Harbour Amendment Bill 2024, I'd now like to report to the Council on the main points of the deliberations of the committee. The purpose of the bill is to amend the Protection of the Harbour Ordinance, PHO in short, to provide for a clearer mechanism to regulate reclamation in Victoria Harbour, in particular large-scale reclamation for the purpose of protecting Victoria Harbour. And on the other hand, for minor reclamations and non-permanent reclamations for the purpose of improving Victoria Harbour, a simplified mechanism will be introduced under the bill. Members of the Bills Committee generally support the proposed amendments set out in the bill. The Bills Committee held 5 meetings with the administration and received oral representations from 18 deputations at one of the meetings. The Bills Committee recognizes that the bill introduces a mechanism for the Chief Executive and Council to determine whether the presumption against reclamation, the presumption in short, has been rebutted so as to strengthen the regulatory regime for major reclamation projects. This will strengthen the regulatory regime for major reclamation projects and enhance the clarity and transparency in the application of the presumption. However, the Bills Committee also notes that there are queries in the community about the proposed mechanism undermining the role of the court in the protection of the Harbour Ordinance, or even taking back the power of the court and failing to exercise effective checks and balances on the government's administrative power. There are also views in the community that it will be difficult for members of the public to seek judicial review of reclamation works after the legislative amendments, thus depriving the public of the right to challenge the legality of reclamation works by way of judicial review. The administration explained that there is no provision in the existing PHO requiring the court to scrutinize reclamation works, and the court will only hear cases where there are applications for judicial review against the decisions of individual departments in relation to reclamation works. It emphasized that after the legislative amendments, members of the public who are dissatisfied or aggrieved by the administration's decision can still apply for judicial review, and the role of the court under the PHO remains unchanged. The administration also points out that the important public policy decisions in Hong Kong have all along been made by the Chief Executive and Council. The bill, therefore, provides for a decision-making mechanism for major reclamation projects, which is consistent with the existing system. It would be putting the cart before the horse for anyone to question the need to amend the PHO to improve the mechanism by suggesting that a more regularized approval mechanism would reduce the chance of successful judicial review challenges. The administration also advised that as the amendments will institutionalize the regulation of reclamation in the harbour, they should reduce the chance of challenges to decisions made by the government or the Chief Executive and Council. The Bills Committee is concerned how the public would know whether the government has taken on board the views collected in the statutory public consultation process. Members urged the administration to further enhance the transparency of the proposed mechanism to facilitate public monitoring of major reclamation projects. The administration also advised that it will issue LC briefs on the decision of the Chief Executive and Council on major issues and matters of wide public concern. The briefs will set out in detail the rationale and relevant considerations behind the decision made by the Chief Executive and Council and reflect the views and categorizations received during the 60-day statutory public consultation period. The LC brief is a public document and is accessible to the public. In addition, regular reports will be made to the LC Panel on Development and the Harbourfront Commission on the applications which have been found to rebut the presumption and those which have been exempted from the presumption, so as to facilitate monitoring of the reclamation projects by the LC, the Harbourfront Commission, and the public. Considering that the Victoria Harbour is a valuable natural heritage of Hong Kong, the Bills Committee considers it important for the administration to ensure that harbour improvement works initiated by the private sector and carried out under the proposed simplified mechanism are in the public interest. Some members asked whether the proposed facilities would be required to be open for public use upon completion. Members were also very much concerned about how the administration would prevent the proposed simplified mechanism from being abused. Say, for example, large-scale reclamation projects being split into several projects to circumvent the stringent requirements for rebutting the presumption. Moreover, whether the shape of the reclamation area would be regulated or the number of structures, facilities, or installations will be limited to a certain number in order to prevent too many similar facilities at the waterfront. The administration advised that under the proposed simplified mechanism, in granting an exemption for harbour reclamation exemptions, the Financial Secretary must be satisfied that the reclamation is in the public interest, including giving due consideration to its relationship with any other reclamation exemptions previously granted. In addition, the Financial Secretary must also consider the impacts, including anticipated impacts of the reclamation on the harbour. As such, there is no intention to restrict the shape of the reclamation area or to specify the number of structures, facilities, or installations so as to retain an appropriate degree of flexibility. The administration said that in granting exemption, the Secretary may impose appropriate conditions, such as requiring the facilities to be open for public use upon completion, which may be incorporated into the relevant instruments, such as land leases, for enforcement as appropriate. Given that the consultation process under the proposed simplified mechanism is not a statutory mechanism, members suggested that the public engagement components should be strengthened, including adding more ways to collect public views so that members of the public participate in expressing their views and incorporating the process of consultation with LC. Having considered members' views, the administration agreed that apart from consulting the Harbourfront Commission, the relevant district councils and stakeholders, it would also send the proposed reclamation project briefs to the LC Panel on Development and publish it on the website of the Development Bureau to invite views from the members and the public. In addition, some members pointed out that the typical cost of both harbour reclamation improvement works and non-permanent reclamation works was over $50 million, which required the support of the relevant LC panels and the Public Works Subcommittee, as well as the endorsement of the Finance Committee, and that members would act as the gatekeeper for members of the public in vetting and approving the relevant funding proposals. The Bills Committee expects that the bill will be effective in removing the barriers for harbour reclamation or harbour improvement works and non-permanent reclamations, and members are particularly concerned whether harbour reclamation or non-permanent reclamation exempted from the presumption would be subject to the Town Planning Ordinance, TPO, and would be required to go through the relevant statutory planning process under the TPO. According to the administration, most of the harbour improvement works, such as landing steps and viewing deck, are ancillary to the use of waterfront and can be carried out without additional planning process. Even if OZP has to be amended in the future to implement the relevant harbour improvement works, advanced preparatory work would be carried out as far as possible so that the planning process will not hinder the implementation of the process. In response to members' views, the administration will propose a number of amendments to the bill, including amending the long title of the Protection of the Harbour Ordinance and the proposed revised Section 3(1) to read, to protect and preserve the harbour as a special public asset and a natural heritage of Hong Kong, and amending the phrase natural heritage in the Chinese text to read 自然財產 and to amend 天然財產 in the Chinese text to 自然遺產 with a view to enhancing the clarity of the policy formulation and better aligning with reference to natural heritage in the English text. The Bills Committee supports the various amendments proposed. President, here is my personal views on the bill. As the chairman of the Bills Committee, I participated in the scrutiny of the bill. I am aware of the community's concern on protection of the Victoria Harbour. By amending the ordinance, we can improve the mechanism to protect the Victoria Harbour, and it allows us to strike a balance between the protection of the harbour and development. Now, I'd like to focus on the reasonableness of the mechanism and public engagement, as well as future monitoring. Victoria Harbour enjoys a world-class views, and it is a natural heritage shared by everyone in Hong Kong. The current PHO was implemented in 1997. There is a presumption against reclamation. However, the provisions of the ordinance is too simple. There are often challenges and disputes. For example, what does it mean by overriding public needs? And what does it mean by reasonable alternatives? These are vague and confusing. There is no clear guidelines. As a result, when government departments handle reclamation applications, there is great uncertainty. Over the past 20-odd years, the ordinance has prevented a number of harbour improvement works that bring benefits to the public. Say, for example, the reprovisioning and redevelopment of dilapidated piers, and works to enhance safety of waterfront facilities. These works could not be taken forward because of the ordinance. We have been developing Coastal Park and waterfront promenade. They could not be built because of the lack of consent of landowner and OZP restrictions. And as a result, we could not connect all the waterfront promenade. If we make use of cantilever to build boardwalk along the harbour front, it will be considered as reclamation. As a result, it could not be taken forward. And this undermines people's enjoyment of the harbour front. In order to allow people to enjoy the beautiful scenery along the harbour front, I support the exemptions set out under the bill. For harbour enhancement works, such as landing steps, viewing deck, there is a mechanism under the bill to allow Financial Secretary to approve of such harbour enhancement works, and this will prevent abuse of the mechanism. And this is a pragmatic approach. At the same time, the bills sets that the Chief Executive in Council will set out clear mechanism and guidelines on the rebuttal of presumption against reclamation. There will be oversight of the LegCo. There will be public engagement to make sure that the reclamation works are in the public interest. There are views saying that the bill will undermine people's rights to initiate judicial review, and it will undermine the role of the court. First, the people's right to lodge judicial reviews has not been changed. The bills or the current ordinance is never given the court power to scrutinize the application of reclamation. Only when there are challenges against the government's decision can they lodge the judicial review, and the court will be able to make a decision as a result. The bill has only make the decision-making process of the government more transparent and clear. The mechanism will allow us to prevent disputes. Previously, there has been a number of judicial reviews lodged because of unclear guidelines and mechanism. After the amendment, the Chief Executive and Council will have to take into account the professional assessments, the public views, and the LegCo members' comments before they make a decision. This will enhance the transparency of the decision. Through a more regulated mechanism, it will make the decision more objective. Members of the public and the Bills Committee members are concerned about how we can make sure that public engagement will not be undermined while we simplify our mechanism. We have to accord priority to the interest of the public. I'm glad that the administration has taken on board members' views by including two major measures. First, all exempted works needs to be scrutinized by the LegCo. Members can put questions to monitor the reasonableness of all the proposed works project. Second, apart from statutory consultation, the Development Bureau will have to upload the details of the works online. They have to, receive written or oral representations from the people. This reflects that the process is still heavily regulated and monitored, while the public engagement is not affected. People are concerned about whether the mechanism will be abused. Say, for example, they're worried if someone would break down large projects into smaller ones. The government has given us reassurance. For example, the financial secretary will be the gatekeeper, and the conditions will be set out in the land lease. The financial secretary have to look into the accumulated effects of various reclamation projects in the vicinity before they give their approval. Also, the financial secretary may ask the developers to open the facilities for public use upon completion, and these conditions may be incorporated into the land leases. For assessment criteria, I think that the government should set out guidelines on the impact that may be caused by the reclamations visually or on the ecology. And there should be also an assessment mechanism. If there are many similar exemption applications, the government should look into whether anyone is breaking a larger scale reclamations into smaller ones. President, this amendment is not the end of our efforts in protecting the harbor. We have to abide by the overriding public need test. At the same time, we have to guard against large-scale reclamation while relaxing barriers to meet development needs of our city. This will allow people to enjoy the harborfront more, and that the harborfront facilities will meet the people's need better. The amendment will establish a more clear and fair mechanism for reclamation applications. I so speak in support of the Protection of the Harbour Amendment Bill 2024.
Lee.
Dr. Starry Lee. President, I support the Protection of the Harbour Amendment Bill 2024. This is a milestone for Hong Kong. We are breaking down the constraints on our harbourfront development that has been with us for many years, As Mr. Tony Tse has said, our harbourfront development, along with other forms of development, were held back by the harbourfront protection of the harbourfront ordinance. Local residents have been calling for a continuous waterfront trail for a long time. Director Xiaowalong has been calling for tourism everywhere in Hong Kong. Tourists love to come to our waterfront. Starting from 2008, the DAB has been calling for a new waterfront for Kowloon. And that's in line with part of the goal of this amendment bill. We have been calling for the linking up of the waterfront along different parts of Kowloon so that these scattered areas can become one continuous waterfront promenade. The current term government takes the waterfront seriously. The Island East Boardwalk opened in recent months. We have a viewing deck, there are shared tracks, there are climbing facilities. Many people went there. Even tourists snapped selfies there. This shows the government does pay attention to the people's aspirations for the waterfront. We had a discussion about the waterfront in Kowloon even before this bill came to LegCo. The Secretary for Development also joined me and my team on a visit to parts of the Kowloon waterfront where we had problems. We all want a continuous waterfront, but then we have the protection of the harbourfront ordinance. We have the presumption against reclamation. That's holding us back. And then there's the uncertainty mentioned by Mr. Tony Tse. The protection of the harbourfront ordinance is meant to protect our harbour, but the broad brush approach of that ordinance means even minor reclamation cannot go ahead because of the high threshold of the overriding public need that's needed to justify reclamation. And that means even when a project can improve people's experience, when something is positive for the community, such minor reclamation project cannot go ahead. And that's been the case for many years. We all want to protect our Victoria Harbour. Everyone in Hong Kong cherishes Victoria Harbour. We treat the harbour as our most important natural asset. But protecting our harbour should not be a factor holding us back from creating a continuous waterfront promenade. So amending this ordinance can help address this problem. Take Kowloon City, something I am familiar with. There's been a long-standing problem with Ma Hang Chung, Shou Wang Toi section. Now the Kai Tak Sports Park is open. So there is an even more pressing need to link up the different parts. Now you have the Fishtail Rock outside Hoi San Park. You cannot walk past the area because we don't have a continuous waterfront promenade. And then from Whampoa to Tsim Sha Tsui, because of the Green Island cement plant, that waterfront cannot be linked up. With this amendment bill passed, we will be able to build a boardwalk. And then we will be gradually able to put together a continuous waterfront promenade. And then people will get continuous waterfront. Amending the ordinance means we are tearing down barriers. We will have a more flexible regulatory regime. With the bill passed, we will still have rigorous control over reclamation. The Chief Executive in Council will be the top decision maker. And then for minor reclamation projects, there will be a streamlined procedure. So for reclamation involving less than 0.8 hectares, when you want to build a cycling track or build a viewing deck, I hope they don't exceed 0.8 hectares in area. Those smaller projects will fall under the streamlined procedure. I'm all for the amendment. I do not think we're undermining the protection for Victoria Harbour. we are striking a better balance between development and conservation. Now, once the new waterfront of Kowloon is ready, we will have continuous waterfront on either side of Victoria Harbour, one on the Kowloon side, the other one on Hong Kong Island. Once the bill is passed, I hope the government can speed up the work on linking up the Kowloon waterfront. Let's seize this opportunity of the opening of the Kai Tak Sports Park. Let's put in place more art installations so that we can have art, culture, tourism, everything put together. Recently, the government announced its plan for the site in southern Hong Kong. I support that proposal in terms of the direction, and we can put together everything. We have the playground, the gym, so that we can meet the needs of local residents and visitors, tourists. And let's do a public consultation as we're doing. This morning I had a media interview. A question was put to me about whether we would expect large-scale reclamation because of this bill's passage. I said no. From what I have observed, everyone wants to protect Victoria Harbour. No one wants to reclaim the entire harbour. We have a regulatory regime in place. As Mr. Tony Tse has said, we have a rigorous system. We're an open society. When someone puts forward that proposal to reclaim the entire harbour, I will be up against that. It's impossible to reclaim the entire harbour. The proposed amendment here is to allow smaller reclamation projects to go ahead. And we will also have a mechanism to protect the harbour. Another project the community has been calling for a long time, and that's the linkage between Kwun Tong and Kai Tak. Even with this bill passed, that linkage will not fall under the streamlined procedure. Our law is strict. When you visit Kai Tak Sports Park, it's actually very close to Kwun Tong. Why not have a vehicular link between Kai Tak and Kwun Tong and bring greater vibrancy there? It makes little sense. And that's because of the protection of the Harbour Ordinance. And we cannot go ahead with the project even when this bill is passed. We still have to go through the Chief Executive in Council. This Chief Executive in Council has already told me, don't get our hopes too high. Things cannot happen overnight. We can have a healthy discussion about reclamation so that things in Hong Kong can proceed in a sensible way, and all the while we protect our harbour. People also wonder whether we can move faster with straightforward minor projects, so I hope the Secretary can take note. I hope this bill will be passed, and we will exercise the power under the amended ordinance with care. I know the Secretary is fully occupied with the North Metropolis, but please don't forget other projects, energizing Kowloon East, the new Kowloon Harbourfront, for example. Those projects also need attention. And then with the new attraction in Hong Kong, can we also get the project with the Kowloon waterfront started so that we can turn the Kowloon waterfront and the island waterfront into new attractions, and then we can have tourism everywhere. That way, Kowloon residents will see a continuous waterfront soon. I so submit. Dr. Lo Wai Kwok. The BPA and I support the passage of the Protection of the Harbour Amendment Bill 2024. Article 7 of the Basic Law says, land and natural resources within the HKSAR belongs to the state. Those resources are simply managed, used, and exploited by the HKSAR. The revenue will be at the disposal of the HKSAR government. Victoria Harbour is unique in different ways. It's a public asset, it's a natural heritage. The harbour deserves our protection. Cap 531 or the protection of the Harbour Ordinance was enacted as a members' bill in June 1997, there were only 4 sections. Those sections set out the fact that there's the presumption against reclamation. But there's a lack of operational details under the ordinance. A project has to meet the test of an overriding public need before it can proceed, and that's a very stringent threshold. It's a broad brush approach applicable to all reclamation projects, even minor projects. Non-permanent reclamation project cannot go ahead without meeting the test. Even a project involving a boardwalk to enhance public enjoyment with minor impact will have to go through cumbersome processes. And then there are possible judicial reviews down the road. So all kinds of adjustments are needed to projects, and that's undesirable. This has prevented many minor improvements from going forward. Now, as the waterfront on either side of the harbor is taking shape, we want to turn Hong Kong into a more accessible and vibrant place for the enjoyment of local residents and tourists. And it's becoming more obvious that the ordinance is holding back the city. In 2023, there was a public engagement about how to amend the ordinance to better meet the community's needs. The panel on development of Electrical was consulted. The Harbourfront Commission was also consulted. And then a consensus was forged. So that's how this bill came to be. This bill seeks to bring in various mechanisms to regulate reclamation. The bill also sets out how and when we can rebut the presumption against reclamation. The bill also sets out certain exemptions. In this case, non-permanent reclamation can be exempted. For me and other members of the Bills Committee, we support the bill so that we strengthen the regulation of large-scale reclamation. We're also bringing in a streamlined procedure. There are projects that seek to enhance the harbourfront and to enhance public enjoyment. And also for non-permanent reclamation, we are relaxing the restrictions. The bill sets out clearer procedures on reclamation in Victoria Harbour. The administration explained that only reclamation defined under the amended ordinance, meaning land formation at the foreshore or on the seabed, will be subject to the presumption under Section 1, Subsection 1. The new Section 3A is on how you can rebut the presumption against reclamation, meaning A, overriding public need, and the need is compelling at present. B, no reasonable alternative to reclamation, and C, the reclamation is no more than what is necessary to meet this overriding public need. And then we also have the new proposed sections 3B to 3H. Those sections have to do with having the Chief Executive in Council as the decision maker over the rebuttal of the presumption against reclamation. So for projects that fail at the threshold, the bill actually will make things clearer about when we decide to reject a project, because the highest executive authorities will be the decision makers. If people are not happy with the authorities' decision, they can still resort to judicial review. Now, on harbour enhancement reclamation and non-permanent reclamation, we have the new sections 3J to 3T. A specified officer can apply to the Financial Secretary for exemption governing harbour enhancement reclamation and non-permanent reclamation. And then we have the new section Schedule 2, a list of reclamation projects. There are 14 kinds of structures or facilities: waterfront, boardwalk, cycling tracks, viewing decks. Such projects were discussed in the public engagement, and people supported having such facilities. And even when you do build those facilities, they have to meet the new requirement, meaning they cannot be larger than 0.8 hectares. Schedule 2 can be amended via the negative vetting mechanism as subsidiary legislation. Now, for non-permanent reclamation, when they take up an area either below or above water, and they're no more than 3 hectares in area, and that project lasts no more than 7 years, the FS will be able to grant an exemption for such reclamation. There are calls for relaxing restrictions so that we can have more harbor enhancement projects, and then we can improve the experience for local residents and tourists. The government has been responsive by adopting many suggestions of the Bills Committee. The Secretary for Development will move the amendment. There will be a change to the long title to clarify the purpose of the bill, and that is to protect and preserve the harbor as a public asset and natural heritage of Hong Kong. And then there will also be an amendment about the publication of the OPNA report. And then for the exempted non-permanent reclamation, when the works are going on and the exemption is suspended, the permitted construction period will be extended. That is equivalent to the suspension of the exemption. These are pragmatic amendments and deserve our support. All in all, I think this bill shows that we have sorted out the relationship between the presumption and protection of the harbor. The bill also sets out clearly when we can rebut the presumption. And that means greater transparency and more workable. And we're striking a better balance between development and conservation. Madam Deputy, I so submit I support the passage of the Protection of the Harbor Amendment Bill 2024 and also support the amendments to be moved by the Secretary for Development.
Dr. Chairman Kwan, thank you. I speak in support of the protection of the Harbour Amendment Bill 2024. The current ordinance has only 4 provisions. It prohibits reclamations of all scales, and it is out of date. The amendment will enrich the content of the ordinance by continuing to regulate large-scale reclamations. Under the streamlined mechanism, we're going to introduce public engagement to enhance the transparency of the decision. Second, harbor enhancement work that meet the criteria of size will be able to be exempted. The specified area should not be larger than 0.8 hectares. Third, non-permanent reclamations that is smaller than 3 hectares and that occupies the area for no longer than 7 years will be exempted. The amendment is to protect the Victoria Harbour. However, we also have to protect the interest of the people. While we guard against large-scale reclamation, we have to make sure that harbor enhancement works in the public interest will go through all the statutory procedures. Also, in light of city development, the bill will allow for non-permanent reclamations such as tunnel construction. Also, the LegCo will be the gatekeeper. I'm sure that will reassure the people. 2 years ago, the bill was tabled into the panel on development of the LCB. I recognize the efforts of the administration in the process of the scrutiny. I'd like to give my comments on 3 different areas. First, the administration stressed time and again that we have not relaxed any barriers for reclamation. It is proposed that we are going to introduce Section 3(1) to set out criteria where the presumption against the reclamations can be rebutted. Say, for example, when there is an overriding public need, when the need is compelling at present, and when there is no reasonable alternatives. The administration said that in the process, the public can give their comments. And Division 3 has been introduced into the ordinance. The Chief Executive in Council will assess and decide whether the reclamation applications meets the overriding public need test to see if the presumption should be rebutted. The process will alleviate legal disputes by engaging the public. When the administration consulted the panel on development on the bill, they said that they're not going to farm land in the Victoria Harbour for housing supply. In the panel meeting, I follow up with the administration to see if they're going to introduce provisions in the bill to set out the principle. The administration said back then that they did not have any intention to reclaim to provide housing. That's why it's not necessary for them to include that in the bill. I understand their reasoning, and I hope that upon passage of the bill, they will not let their guard down. They should continue to explain the bill to the public to garner public support. Second, the administration's provide a convenience for certain harbour enhancement works application in order for us to connect different harbourfront promenades and to meet the needs to protect people's property and lives during extreme weathers by allowing the construction of wave absorption structures. Say, for example, the administration is going to amend several parts to set out a mechanism such that public officers can apply for exemptions for harbour enhancement works. If it's not larger than 0.8 hectares, then the relevant departments may build structures, features, devices such as a harbour pool, viewing deck, promenade, boardwalk, wave absorption structures, or devices for mitigating extreme climate risks. We have a rising sea level because of climate change. Wave absorption structure and device for mitigating extreme climate risks will enhance people's safety. This is how we can enhance protection for the people. While we retain for flexibility, the administration must assess each and every application strictly so that there will not be any abuse of the mechanism. There shouldn't be multiple reclamations that are smaller than 0.8 hectares in the same area. I'd like to also talk about for example, definition of reclamation and the coverage of harbour enhancement works. We have discussed these areas in detail in the Bills Committee. I have to declare interest. I'm a consultant to a construction company. I so speak in support of the bill. Thank you. Mr. Andrew Lam, Deputy President. The Victoria Harbour existed before we were here. Its function's been changing over time. As an international metropolis, Hong Kong has the Victoria Harbour as its brand. We have a consensus to protect it. However, we should not freeze the size and image of the harbour just because of some ideology. The protection of the Harbour Ordinance has only 4 provisions. It was enacted and passed before the reunification in 1997, and it created some problems. Until today, there were people who tried to sell fears based on some outdated provisions. We have just commissioned the Island East Boardwalk. If its application was not challenged some years ago, then we would have saved millions of dollars and enjoyed the well-connected harborfront in the Hong Kong island earlier on. Now the climate has been changing. It affects everyone in the world. So we have to guard against such risks. We should not allow the overriding public need test and the 4 provisions in the PHO to override everything. We have to make sure that while the government is protecting the harbor, we should be able to develop. I think that the law should keep up with the time so that we can meet different challenges. Now, the bill have 5 different parts. The people can still lodge judicial review if they are aggrieved by the government's decision. The bill sets out clearer and more transparent mechanism for the application or assessment of reclamations, such that public officers have rules to follow. They don't have to make any guesswork on the criteria of the overriding public need test. We amend the bill to introduce a mechanism and to streamline the procedures of harbor enhancement works. 3 types of works are involved, including the 14 structures, features, or devices set out in the list that should not be larger than 0.8 hectares, including viewing deck and promenade, in order to enhance the connectivity of waterfront promenade. Second, non-permanent reclamations. These structures have to be demolished after the work's been completed. The third type is reclamation projects. The Financial Secretary will have to look into whether the reclamation is in the public interest. However, disputes may still arise despite the clear mechanism. The administration is well aware of the sensitivity of the bill. During the scrutiny of it, I stressed time and again that the provisions of the bill must be clear and it should be easily invoked. The bill sets out very clearly the types of structures, features, device allowed, and the specified area, that is the portion of the water body occupied underwater or covered at or above the water surface starting from the high water mark along the shore. In real-life examples, take the Central Kowloon route as an example. Those above the water will be considered temporary works, and those structures underwater will be considered reclamation works. If there is no clear definition in the bill, then in the future, similar projects may be challenged and questioned. And once there is any queries, there could be overinterpretation of the laws. I think that the administration should offer clear administrative guidelines to make sure that the public officers will have guidelines to follow. We should ask the relevant officers to submit progress report to the Financial Secretary. The bill is forward-looking, clear, and easily understood. Take Section 3A, Bracket 2 as an example. The administration said that the non-permanent reclamation may be allowed to be extended beyond 7 years. To put it simply, if there is a suspension of exemption, then the suspended period will be included in the permitted construction period. And very often, the works is concentrated at the later stage, and if there is extreme weather such that application for extension could not be filed 6 months before the end of the construction period, the Financial Secretary will have the discretion to extend the exemption. On Section 3H(6), if the after the Chief Executive and Council has made a decision, and if they were not aware of the irregularities of the application, the decision is still valid. This is not unique to this bill. I think that the administration should explain about it more clearly. Lastly, I thank Mr. Tony Chen, Chairman of the Bills Committee, members of the BC, the Secretariat, and the administration for their hard work on the scrutiny of the bill. President, I so speak in support of the protection of the Harbour Amendment Bill 2024 and the amendments to be moved by the administration.
Mr. Bill Tang, thank you. Deputy President. Apart from myself, Mr. Stanley from the FTU will also speak on behalf of our party. He will talk about how the existing protection of the Harbour Ordinance imposed restrictions on the development of Hong Kong. I am a GC member of Kowloon East. I am all for this bill. I am also a member of the Bills Committee on Protection of the Harbour Amendment Bill 2024. I'd like to thank the Secretary as well as the Harbourfront Commission for their efforts. I, as a member of the Bills Committee, have put forward a few suggestions. In 2021, the then Legislative Council member, Ms. Alice Mack, as well as the entire FTU team, already asked whether the area to be protected have to be covered so widely. Could we go back to the definition of harbour, that is from North Point, Hong Kong to Western Cross Harbour Tunnel in 1997, Ching Yi Container Terminal, as well as the Kai Tak Old Runway. These are all part of the harbour in the public's mind. This bill will remove the relevant restrictions, and it will facilitate people to make better use of the harbourfront, and it will encourage people to have water-based recreational activities. But I do think that we have to keep moving with the times. Harbour is not just a natural heritage. The Victoria Harbour is a result of reclamations at different times. So is it a natural heritage? I am skeptical. But it definitely marks the development of Hong Kong over the years. I think we have to make good use of the Victoria Harbour and maximize the social as well as commercial value of it. We can be more creative. For example, we can change the name of the Victoria Harbour. Well, I think this bill will allow us to make better use of the harbour, and it will encourage people to take part in water-based activities. The bill suggests a statutory limit of 0.8 hectares, and there are 14 works covered in the schedule to the bill. This shows that these are going to be works that will facilitate people in taking part in water-based activities. We like landing piers on both sides of the harbor. For example, in Kowloon East, as well as other places, the major water body is in Kwun Tong. The water body between Kwun Tong and the Kai Tak Old Runway is a very good spot for developing water sports activities. I think it is comparable to Shingmun River in Sha Tin in terms of its value. However, because of the existing protection of the harbor ordinance, we lack landing facilities, viewing decks, water-friendly facilities. There's a lack of facilities for boats or dragon boats to berth there. There's a lack of flexibility currently. Upon the passage of the bill, people will be able to better enjoy the harborfront, including the cycling track, and this bill will facilitate the development of water sports. Because of this, I'm all for this bill. However, is this enough? I hope the government will keep reviewing the ordinance. Within the statutory limit of 0.8 hectares, well, on this point, we have several discussions during the Bills Committee meetings. Is this enough to build a breakwater? We could build a marina or a typhoon shelter with this statutory limit. Some asked whether it is enough to build a breakwater with the 0.8 hectare limit. And with a floating pontoon, the limit will not be enough, and there won't be enough space for people to get onto their yachts if we are to build a marina. So my suggestion is that we pass the bill first and then we keep reviewing the ordinance. I hope the government will make good use of the harbor as it decides how to facilitate development and make use of the harbor. I'm thrilled that the bill is introduced because I think Yau Tong Bay is quite suitable for a marina. Yau Tong Bay is part of the Victoria Harbour, but in the past there was nothing we could do because of the restrictions. After the passage of the bill, we will see breakwaters there. In North Point, there is a popular photo-taking spot like the East Coast Park. We can build a similar facility in Yau Tong after the passage of the bill. We can have breakwaters in Yau Tong Bay. This will facilitate the building of a marina. People will be able to enjoy the harborfront in Kwun Tong and even through the breakwaters get into the water. So this bill will allow people to have a more diversified and new experience at the harborfront. There are views in the community that the bill is undermining the power of the court. Well, we are simply setting things right here. We are formalizing the regulatory regime. The overriding public need test was put forward in the 2004 court judgment, and the cogent and convincing materials are now going to become the OPNA report. So we're formalizing the regime proposed by court. We're introducing the mechanism, an approval mechanism, with the CE in council as the decision maker. There will be greater gatekeeping. This is better than the existing regime in which initiating departments or the relevant departments are preparing on the cogent and convincing materials themselves. Some people are spreading rumors and they are criticizing the bill without justifications. They say that the government is becoming judge of its own cause and that it's undermining the power of the court. I think the bill is simply setting things right. We will have a more formalized regulatory regime. The FTU has been calling for the government to remove the barriers so that there could be development at the harbour front. I've been calling for a CBD2 in Kowloon East so that we can make better use of the harbour. For example, I hope that there could be a bridge that links up the Kai Tak cruise terminal and the Kwun Tong harbour front. I so submit. Dr. Frankie Yon, I speak in support of the protection of the Harbour Amendment Bill 2024. The Victoria Harbour is a symbol in Hong Kong. The harbour front we have does not only hold the memories we have, it also represents our expectations on having a better life. The current ordinance is restricting diversified development of the harbour front. The purpose of the bill is to remove the relevant barriers and restrictions and enhance the connectivity of the harbour front as well as its functions. The DAB supports the bill and we approve the direction that the government is taking. We think that there should be a strengthened regulatory mechanism. On the other hand, for harbour enhancement reclamations as well as non-permanent reclamations, if they could strengthen the functions of the harbour and improve the connectivity, they should be relaxed in terms of the restrictions. The existing ordinance was established in 1997 according to 2004 and 2008 court judgments to rebut the presumption against reclamation. There needs to be a high threshold. However, this broad brush approach applies to all kinds of harbour reclamations, including small or minor reclamations and non-permanent reclamations. This stringent threshold has brought about negative impacts because reclamations of different scales have to pass the overriding public need test. One has to prove that there is no reasonable alternative to reclamation in order to pass the test. The high threshold has put a hold on a lot of small or minor reclamation works. For example, the East Coast Boardwalk has recently been commissioned. From the preparation work to discussion and the final construction of the boardwalk, we went through lots of procedures, public discussions, studies, and administrative processes. Till today, we haven't seen the commissioning of the entire boardwalk. The western section has been opened, but the eastern section will only be opened in the second half of this year. Members of the public have been aspiring for a greater harbour front. We don't just want an open space, but we want a harbour front that can offer water-based activities and arts and cultural experience and tourist attractions. because of different structures and buildings, part of the boardwalk or part of the promenade had to be interrupted. And this bill is not just providing a legal basis, it's also allowing us to make greater use of the harbor. Harbourfront development has been significant over the past few years. However, we've seen challenges. Over the past 6 years, the promenade lengthened from 19 kilometers to 27 kilometers. 55 venues spanning 50 hectares have been opened up. The goal is to lengthen it to 34 kilometers by 2028. Part of the harbourfront awaits connection from Tsim Sha Tsui to Yau Tong. There are many structures and buildings breaking up the harbourfront promenade. The part in Kwun Tong and Cha Ko Ling Park have already been opened up, but there is yet a plan to open up the sections in Yau Tong. We've been speaking about our visions for the harbourfront for some 20 years now. Ma Hang Chong Song Wong Toi and To Kwa Wan as well as Whampoa, the sections of the promenades there await minor reclamation works and works to build boardwalk to improve the connectivity. The core of the bill is to strike a balance between preservation and our protection of the harbor and development. It allows greater flexibility in taking forward reclamations. Part of the bill targets minor reclamation works. There are 14 types of construction, including promenade, boardwalk, cycling tracks, viewing decks, moors, which will be exempted from the presumption as long as they do not exceed the statutory limit of 0.8 hectares. These construction works will provide convenience to members of the public and allow them to take part in water-based activities there. Take the new Praia in Kennedy Town. If there is a boardwalk, it could be connected to Belcher Street, and it will form a more continuous promenade. Also, non-permanent reclamations will be included in the exemption, given that it does not exceed 3 hectares in terms of its reclamation area, and that the total duration of the works does not exceed 7 years. For large-scale reclamations, the bill retains the high threshold. That means these works will not be exempted. The reclamation proponent will have to submit reports, and there will be a 60-day public consultation. The CE Council will decide whether the presumption should be rebutted based on the discussion. We have to take into consideration whether there is overriding public need and whether there is no reasonable alternative to reclamation according to the previous court judgment. We are passing the gatekeeping role from the court to the government. At the same time, we are retaining the role of the court while we do not make the procedure too judicial. This bill is not to open up a gate for large-scale reclamations. Over the past 2 decades, only 5 large-scale projects were approved involving about $17 million. This shows that the existing mechanism is onerous. This simplified mechanism will help save costs and remove hurdles. I believe the bill will help us lengthen the promenade and improve the living quality of members of the public. I believe in future, both sides of the Victoria Harbour will be able to allow tourists as well as members of the public to really experience the harborfront improvement works, including revitalization of piers and improvement of breakwaters, can enhance the harborfront in the long run. The harborfront could be a treasure that integrates arts, cultural, and commercial elements. All in all, this amendment is not just an adjustment to our legal framework. At the same time, we are removing barriers as well as protecting the harbor at the same time. We can inject new impetus to our economy by enhancing our harborfront. We hope that we can have a continuous harborfront promenade and that we will have a bright future. Thank you.
Mr. Scotland. Thank you, Madam Deputy. Victoria Harbour is Hong Kong's most unique and iconic attraction. It's our shared asset. It's the core of our city. The protection of the harbour ordinance has been protecting our harbour, but the law also imposes a constraint, and that means cumbersome processes in reclamation project. The government has been trying to drive a harbourfront economy, so now we're trying to find a pragmatic balance between development and conservation. I support this amendment bill. The proposed Section 3H empowers the Chief Executive in Council to decide whether to rebut the presumption against reclamation when there is an overriding public need. From our discussions and the deputation hearing, we can see the public attention to Section 3H. Section 3H is not there to replace the court. What we're doing with Section 3H is to take the three principles laid down by the court and put those into the law. The three principles being compelling and present need, no reasonable alternative, and reclamation no more than what is necessary. The government has been trying to explain the proposal to allay concerns. What we're trying to do is to have more enhancement projects such as boardwalk or cycle tracks. Such minor projects have a minimal impact on the harbor, but the enhancements will give people a better experience, and that will give a massive boost to a harbor economy. Then there are concerns in the economy, in the community, that we are opening the floodgate to large-scale reclamation. The government has said time and again that there were no plans for large-scale reclamation for housing. The bill also states clearly that there are constraints. For non-permanent reclamation projects, they have to end within 7 years. And then there are administrative instructions for departments or any other project proponents that are government departments. They have to consult the Harbourfront Commission, the district councils, and stakeholders. The reclamation projects have to be uploaded. The details have to be put online. And if people still have concerns, they can resort to judicial review. So we have belt and braces. We're upholding the rule of law, and we're also doing away with the broad brush approach under the current regime. I'm from the geographical constituency of West Kowloon. Along with my party and other electoral members, such as Professor Priscilla Leung, who also represents West Kowloon, let's take a look at West Kowloon. Along Sham Shui Po, you cannot reach Nam Chuen Station or Lai Chi Kok along the waterfront. There's the cargo loading and unloading area. There are cargo areas. And if you want to walk from Olympic Station to Lai Chi Kok Station, you have to go inland and you have to walk parallel to Lin Cheng Road. That's bad for the pedestrian. A fragmented waterfront affects not just accessibility, you're also putting the waterfront resources to waste. In the future, smaller reclamation projects can go through under the streamlined procedures. We will be able to link up the fragmented waterfront areas in Kowloon. We will be able to build boardwalks. we will be able to build piers for water transport, and then we will be able to create a vibrant waterfront promenade in West Kowloon. Now, for viewing decks, cycle tracks, and water sports facilities, they are covered under the bill. These projects could not go ahead because of the prohibitive costs and also risks of legal challenge. With the bill, those projects may be able to get a chance. Now, take the proposal to develop the inward freight pier in southern Hong Kong. There are plans. With this bill's passage, we can have not just boardwalk, we can have public space, we can have space for parents with their children to spend time. And then there's also an idle site outside Chengsha Wan Food Market. With the bill's passage, can we move faster? Can we have more waterfront boardwalks or outdoor performance venues? Or light refreshment stores and also places for water sports? That will mean a better experience and also revitalize the local economy. The presumption against reclamation is there to protect Victoria Harbour. But now we're trying to jumpstart the harbourfront economy. But is a ban on reclamation the same as protecting our harbour? What we end up with is idle waterfront sites and fragmented waterfront sites. After this bill's passage, we will still protect the harbour. We're simply going to protect our harbour in smarter and more efficient ways so that minor projects will be able to go ahead with oversight in place. And then we can have a Victoria Harbour that is even more vibrant. I support the Protection of the Harbour Amendment Bill 2024. I so submit. Mr. Stanley Ng. Madam Deputy, on behalf of the FTU, I fully support the Protection of the Harbour Amendment Bill 2024. Successive terms of legislative members have been campaigning for this, and we are putting things right with this bill. As early as 2021, I made the argument that the protection of the Harbour Ordinance had been holding back our housing development. Now I want to cover the history of the ordinance and why we are having all these issues. I will also cover the work done by the FTU. Just then, Mr. Bill Tang has already covered the merits of this amendment. The protection of the Harbour Ordinance was enacted on the 27th of June 1997. The bill was enacted when the Sinner of a Thousand of Years, Chris Patten, was in power. That meeting took 5 days. 16 members' bills were discussed. The protection of the Harbour Ordinance was part of it. The bill was proposed by people who were against China and Hong Kong. Those people knew there would be no through train. In February 1997, the NPCSC made a decision on existing laws in Hong Kong. So those anti-China forces with nefarious intentions tried to create fait accompli and tried to sneak in things and turn them into laws of Hong Kong, and those became pitfalls for the HKSCR government. So there was a bill put forward by the SCR government to the provisional legislature back then. There was a proposal to suspend this implementation of certain ordinances, including the protection of the Harbour Ordinance. That was a great opportunity, but at the second reading, certain lawmakers said there would be no large-scale reclamation anyway. So the protection of the Harbour Ordinance was excluded from that suspension list. And then over the years, the protection of the Harbour Ordinance was made even more rigorous over the years. In 1999, the ordinance was expanded in its scope of application from the core harbourfront to places like Rambler Channel between Chunwan and Qingyi. And then after the year 2000, in 2004, there was a case of judicial review. The Court of Final Appeal ruled that proposed reclamation would need compelling, or rather cogent and convincing materials to justify that project. Overriding public need had to be established before reclamation could go ahead. And then 2008 came another case of judicial review. The CFI ruled that any temporary or permanent reclamation would be subject to the ordinance. They would be subject to the presumption against reclamation. So with the straitjacket in place, no option was left for housing or industries within the Victoria Harbour. So the reclamation projects for Wan Chai and Kwun Tong were scaled back. Back in the colonial days, there were also proposed reclamation projects. Those projects fell by the wayside. The Yao Tong project, a private initiative, also fell by the wayside. Those projects would have created 620 hectares of land, enough land to accommodate 370,000 people. Successive governments tried to propose land for development, and then opposition came in left and right, so the government's hands were tied, and that led to a conservative approach and slow progress. So over 28 years, home prices rose up and up. The waiting list for public housing got longer and longer, and housing for grassrooters became smaller and more costly. With the current term government, land development procedures have been streamlined. We have the Northern Metropolis, the transitional housing, building light public housing, and also proposal on basic housing units. Now we're seeing things being turned around for housing. So the protection of the Harbour Ordinance from 1997 was the beginning of the government tying its own hands. With the current ordinance, the fragmented waterfront areas cannot be linked up. That's because the current definition of reclamation refers to land formation at the foreshore or on the seabed. Even putting in the pile counts as reclamation. And there's a huge gap between piling and what we take to be reclamation. People want a boardwalk or landing steps. Still, those projects cannot go ahead because cogent and convincing materials are needed to justify projects and the costs become prohibitive. So now we only have the East Coast Boardwalk. But then starting from 2006, with the effort of FTU councillors at LegCo and district councils, East Coast Boardwalk will fully open in the second half of this year, and that's taking 19 years. That's because of the flaws with the enactment of the protection of the Harbourfront Ordinance. We had Mr. Wong Kwok Hing in the past, and then the former LegCo member, Ms. Alice Mack. They have been exploring different possibilities. Other members have been calling for a boardwalk. Mr. Wong Kwok Hing, Mr. Kwok Wai-keung and Mr. Bill Tang have all put in the work. In 2021, Ms. Alice Mack, who was a electrical member at that time, put forward a member's bill. She was trying to resurrect the definition of the Central Harbour from 1997. Her member's bill proposed to empower the Chief Executive in Council to approve reclamation outside the Central Harbourfront area as a way to address the presumption against reclamation. The proposal was discussed at the panel on development. Members shared their ideas, and that laid the basis for the government's proposal. But then we had the electrical general election coming up. The proposal went nowhere and did not make its way into a proposal. The Protection of the Harbour Amendment Bill 2024 has responded to our cause. This proposal, in some ways, is more aggressive than ours, but more conservative than ours in others. This bill here is more ambitious, in the sense that reclamation smaller than 0.8 hectares and non-permanent reclamation can go ahead under a streamlined procedure. The direction of the bill is right. We are putting things right by taking this step, and this is good for enhancing people's experience. I so submit I support the amendment.
Dr. Priscilla Lang. Madam Deputy, I speak in support of the Protection of the Harbour Amendment Bill 2024. I think the focus of the amendment is how we can protect our harbour and to better protect our harbour front. We have to strike a balance between the two. I entered the LCB in 2008. At that time, together with 30 district councillors, we proposed a connected waterfront promenade along the West Kowloon. We invited scholars and experts to plan for this promenade. They've proposed some criteria. The promenade, say for example, have to be connected, should be convenient. It should be open to the public. Everyone should be able to enjoy the promenade. There should be a water-friendly culture to build. In order to achieve all these goals, we have to overcome a number of obstacles. We are all familiar with the Green Island Pier. This is what prohibits us from connecting the harbourfront along the western part of the Kowloon. We want to have a trail to allow the elderly to walk and to allow young couples to enjoy their time together. There should be a round the island trail connecting the western and the eastern part of Kowloon and the entirety of the Hong Kong island. We have a number of blind spots along the coastline of Kowloon. We have this so-called Protection of the Harbour Ordinance. Of course, it would be best to have as few reclamations as possible. I've been advocating against the construction of a large number of skyscrapers in the same area. We have a lot of them in Wang Pao, for example. Recently, in the southern part of Hong Kong, we have been working with economists, scholars, and experts to promote public-private partnership in order to connect the waterfront promenade in Hong Kong. There should be businesses along the promenade as well. A long time ago, we have a Pokong Pier where we could enjoy coffee with our classmates at night. A few decades have passed. Our economy and the city is very well developed. I grew up along the harbor front because I have used to live in Chun Wan and I go to school in McDonald Road. So I see the Victoria Harbour every day. In 2000s, when I went to the beaches, I could not swim, and when I went to the outlying islands, the beaches disappeared. When we look down from the peak, a lot of skyscrapers actually block our views of the ocean. I moved 3 motions in my first term as a LegCo member on how we can better connect the waterfront promenade and how we can better protect the harbor. Against such background, I think the reason why we have such beautiful harbors because of the efforts of our members. Now we have the Victoria Harbour race, and now the water is clear enough for people to swim. And we actually initiated an action to advocate for Tsuen Wan, Cheung Sa Wan, Hong Kong, Kowloon East, Aberdeen, and to put in place water testing in certain blind spots. And that's why we have this harbor race in Wan Chai today. When we're trying to connect the waterfront promenade, we're faced with legal challenges. The harbor enhancement works have to be confined within 0.8 hectares. I think that this is a way for us to strike a balance between the development of harborfront and protection of the harbor. Because harbor enhancement works is to allow people to enjoy the waterfront better. I'm sure that the residents in the Hong Kong is well aware of this. After connecting the waterfront from Tsim Sha Tsui to Wan Chai, people were able to sit along the promenade during Mid-Autumn Festival. Many families were able to appreciate the moon. This, in turn, enhanced people's sense of happiness. By removing barriers, we'll be able to build a dream of having a round-the-island trail along the harbor front. If we are to put in place minor-scale reclamations, we have to have regards to the public needs, the economy, and the environmental concerns. Only when there is no reasonable alternative to the reclamation and that the extent of the reclamation does not go beyond the minimum of that which is required by the overriding public need can the presumption against reclamation be rebutted. And I think that this is a way to constrain the scope of reclamation. In the bill, it is clearly stated that organizations or departments filing for non-permanent reclamation exemption applications have to make a report to the public. And public engagement exercise has to last for at least 60 days. People are concerned about the Victoria Harbour. In West Kowloon, a lot of people complained about buildings being too close together, and they were able to look into other people's apartment from their own. We're not trying to remove barriers for developers to build wall effect buildings. What we're trying to do is to strike a balance between economic development and protection of the harbor. So I fully support the amendment. I think that the administration or departments that is going to file for NPR exemption should not be tempted to break down larger reclamations into smaller ones. If that happens, people may feel deceived. I hope that this will not happen. Relaxing barriers is a good thing. I hope that by passing this bill, people will see this bill as something that will benefit them. When we're going to amend the bill again, we will definitely conduct another round of public engagement. And only by this will the bill be more convincing. Our dream is to have a round the island, around the territory, green trail. We hope that the waterfront promenade will be well connected and people will be able to feel a clear breeze from the harbor. Madam Deputy, I also speak in support of the bill. Thank you. Dr. Sixian. Thank you. Victoria Harbour is our city's signature and landmark. It is our unique natural heritage and public asset. Victoria Harbour is viewed as one of the 3 greatest night view of the world. So we must try our very best to protect its beauty. First of all, I'd like to thank everyone who's worked on protecting the Victoria Harbour. Mr. Look Kong Wai, Mr. Choi Kasun, and friends of the Society for the Protection of Harbour. They have been working on protecting the harbor since 1995. That's why the PHO was passed and the unique position of the Victoria Harbour was affirmed. In 2004, the Court of Final Appeal set down criteria on presumption against reclamation. In 1996, there was a reclamation project. 2001, the Green Island Cement Pier reclamation projects. 2004, Wan Chai reclamation projects, and the 2007 Central reclamation projects. Through a road-riding public need test, Victoria Harbour can be well protected against short-term development needs. Here, I'd like to extend my gratitude to everyone who has tried their very best to protect the Victoria Harbour. The administration proposes this bill to allow for flexibility and room for harbour enhancement works. Say, for example, promenade, viewing deck, cycle track. These works may be able to enhance the waterfront so that people can enjoy it better. In principle, I think that non-permanent reclamations and harbourfront enhancement works should enjoy a more streamlined process so that administrative departments can take forward harbour enhancement works that benefit the public, so that these projects will not be delayed because of cumbersome procedures. So I support the removal of barriers so that the value of the Victoria Harbour can be better reflected. But I have to point out that the process of public consultation for this bill is lacking. The administration said that the Harbourfront Commission, the district councils, and relevant stakeholders have been consulted, but there is little room for the public to give their views on any proposed reclamation projects. The administration should give the public more channels to voice their comments and suggestions. The administration proposes that under the streamlined process, there should be more ways to collect views. They are going to publish the proposed reclamation projects on the Development Bureau's website, and they're going to send the relevant project details to the panel on development of the LCB. These are some of the amendments proposed by the administration, but that's not as effective as statutory consultation process. I think that the administration should include all these public consultation procedures in the bill. Madam Deputy, the administration should encourage public participation in policy making. These days, it's difficult for the people to give their views on government policies. We're worried if the government is actually listening to the people. Are they actually taking on board their comments? On the recent cut of student grant of 2,500 and the reformation of the medical charges and fees of public hospitals, there has been a lack of public consultation. The government must have regards to the public interest when they formulate their policies. Under the town planning ordinance, the land resumption ordinance, the government is setting out the principle of public engagement and public participation in different ways. There is not a standardized public engagement procedures. Take UK as an example. The highest court of the UK says that there are few elements to public engagement. First, the public engagement must be done in the process of the design of the project. Second, the project proponent must give enough details of their project in order to allow for sufficient consultation. Third, there must be enough time for the public to view their comments. And fourth, the public's views must be duly considered. So I hope that the government will consider these set principles when they consider reclamation applications in the future. There is an addition of Section 3H in the bill. According to the proposed amendments, the Chief Executive in Council will be the one to decide whether the presumption against reclamation is going to be rebutted. This amendment brings about a fundamental problem. The government will be the project proponent and the decision maker. It seems that they are deciding on their own applications. I don't think that this is fair. The purpose of having the PHO is to have the court to scrutinize the project proposed by the administration. However, the amendment entirely changed the process. In the CSA, I'm going to give my views in details on this area. I have a few requests. First, the government must undertake that the Chief Executive in Council will explain in detail how the 3 criteria for rebutting the presumption has been met instead of just giving us the decision. Second, the administration said that they're going to publish the reclamation projects on the Development Bureau's website. I asked the administration to also publish the comments from the public on the website, and they have to send all these comments to the panel on development of the LCB. Third, the administration should also undertake that they're going to report to the Harbourfront Commission and the LegCo the NPR exemptions that they have granted. I asked them to also include the public interest assessment and the EIA conclusions instead of just making some lists. Fourth, for harbor enhancement works initiated by the private sector, the government should set out stringent criteria to make sure that these works actually bring about benefits to the public. There should be the work should be open to the public, for example. Fifth, for 3H(6), the government said that it only applies to special cases. Madam Deputy, I have great reservations on 3H, so I will abstain from voting.
Mr. Frankie Yek. Deputy President, the existing protection of the Harbour Ordinance adopts a broad brush approach that applies to all kinds of reclamations. It restricts us from taking forward any kinds of reclamation works at the harbour. Therefore, the Liberal Party supports the bill, which strikes a balance between protecting the harbour and developing it. The ordinance was enacted in 1997. The Society for Protecting the Harbour said the central reclamation works was against the law, and there was a judicial review. And there was a court judgment afterwards. According to the court, a overriding public need test must be satisfied, which include 3 criteria. 1, the need is compelling and present. 2, there is no reasonable alternative. 3, the extent of reclamation is minimal. Since then, we have seen a stringent threshold for passing the test and taking forward reclamations. The government spent $8.2 billion to build the Kai Tak Cruise Terminal. Since the commissioning of the terminal in 2013, we have seen very little usage rate of the terminal because of lack of transport facilities. When there is a cruise, we have to make special arrangements to have taxis and buses there. We have thousands of visitors arriving every time there is a cruise berthing, and it is hard to divert the crowd or disperse the crowd within a short period of time. That's why there were many complaints from tourists. To mitigate the problem concerning transportation there, I suggested that there should be a landing facility so that when there is a cruise, there could be ferry services from Kai Tak to Tsim Sha Tsui or Central. While the floating pontoon would only take up a small area of the harbour and would cause minimal impact on the harbour, there were views that the shadow posed by the floating pontoon would cause impact on the seabed. And the government was not willing to make tests on the issue. That's why we still don't have any floating pontoons, and there is still a lack of transport facilities around the terminal. The Liberal Party speaks in support of the bill so that there could be minor or small-scale reclamation works as long as they meet the criteria. The Victoria Harbour is a valuable asset. We hope the public could make good use of the harbour front. This will pose a better life for the public. The government has been proactively developing harbourfront promenades in recent years to share the asset with the public. Some industries have to carry out their works at the harbour front, such as repair works and cargo loading and unloading. Take the western cargo loading and unloading area. Part of the land was taken back by the government to develop the promenade, and therefore we lack space for such operations. Cargo loading and unloading could affect the supply of materials for the 7 million people in Hong Kong because these supplies cover groceries and construction materials. these goods are transported to all parts of Hong Kong from the loading and unloading area. To improve people's life, the government has been developing the harbourfront, and our party understands that, but we have to strike a balance. We have to take into consideration operations that require the harbourfront area. Deputy President, I'd like to talk about the Harbourfront Commission. The Harbourfront Commission is an important advisory body. Currently, the Commission is composed of representatives from the engineering, design, or environmental protection sector. Therefore, we only focus on beautifying the harbourfront or adding facilities to the harbourfront. We haven't thought about how we can integrate commercial elements to the harbourfront. Therefore, I think we should include the relevant trades and sectors into the Harbourfront Commission so that we can strike a balance. I speak in support of the bill. Thank you. Mr. Dennis Leung. Deputy President, I speak in support of the protection of the Harbour Amendment Bill 2024. The FTU protects the rights of workers and the grassroots. We take into consideration people's living quality and the long-term development of our society. The Victoria Harbour is crucial to our economy, and it is used by 7 million people in Hong Kong. The ordinance has been enacted for some 26 years. While we care about environmental protection, we also see restrictions posed by the ordinance in terms of restricting the development of Hong Kong. This bill is not to overturn the protection of our harbour. Instead, we want to strike a balance. This bill has to do with the long-term development of the Victoria Harbour. We want to protect the collective memory of Hong Kong people. At the same time, we want to inject new impetus to the harbour. Since 1997, reclamations have seen huge restrictions because of the ordinance. As time changes, as we need more development, we see problems. There are 3 criteria under the overriding public need test. 1, the need is compelling and present. 2, there is no reasonable alternative. 3, the extent of reclamation is minimal. This lacks flexibility, and this restricts the development of our city. According to the Development Bureau, over the past decade, there have been 17 reclamation projects. Because of the 3 criteria, they've been restricted. They include building facilities, barrier-free access facilities at the pier, connecting the promenade, as well as expanding the central pier. These facilities could have improved people's lives, but because of the overriding public need test, because of the high threshold, the reclamation works could not be carried out. In 2021, the government planned to expand the open space at Kwun Tong Harbourfront. It covers an area of 0.2 hectares, but because of a judicial review, we did not get the green light. This put a hold on the revitalization of the harbourfront. This bill gives a green light to reclamation projects. There is an approval mechanism under the bill. For example, for breakwaters projects, it could be approved directly by government departments. For enhancement works, such as widening boardwalk, we can have relevant assessment mechanism for that. And for building new piers, they could also be carried out. Within 5 years' time, we could complete projects at 12 points along the promenade, and this could benefit 3 million people in Hong Kong. We have the consensus of the public. In year 2023, according to the Development Bureau's consultation outcomes, 82% of the respondents supported enhancement works at the harbour, and less than 9% were against this. People were of the view that the existing ordinance is not in line with the current needs. Also, SMEs, take the operators in Hong Kong as an example. Because of the old facilities, we could not connect the promenade. If we could improve the connectivity in Tsim Sha Tsui, we could increase footfall by 15%. Some said the bill might cause damage to the harbor. However, I think there should be a win-win situation. It will allow people to get closer to the harbor. I suggest the following. First, there should be alteration of space for idle container terminals. They can be turned into water sports center. This is in line with the Sydney approach. Second, we should have ferry services that connect the West Kowloon Cultural District and North Point. Thirdly, between Causeway Bay and Wan Chai, we could make use of AR technologies to display the history of our harbourfront. These projects do not require large-scale reclamations, but they could unleash the huge potential of our harbourfront. I think this can help create 5,000 jobs and attract over 2 million visitors to Hong Kong. To ensure transparency and fairness, I suggest the following. First, we should strengthen the function of the Harbourfront Commission. There should be a monitoring committee composed of representatives from the engineering as well as environmental protection sector. Also, we can learn from the Tokyo approach. For large-scale projects, there should be public forum and discussions to encourage participation of the public. Thirdly, there should be different levels of works. There should be ecological preservation schemes. Fourthly, there should be a preservation fund. Less than 3% of the construction fee should be for long-term study so that we can ensure the ecology and tourism development of our harbourfront. Protection of the harbour should not be an excuse for us to stop developing the harbour. From London to New York, cities around the world show that we can preserve our harbour and at the same time develop it. This bill creates a valuable opportunity for us to break away from our previous mindset so that we can build a sustainable harbour for our future generation. I urge everyone in Hong Kong to support the bill so that we can have a continuous harbourfront promenade of vitality. I so submit. Thank you.
Professor Lau Chi-Pang. Thank you.